Good afternoon and welcome back. I'm Marcus Peter. The USCCB is urging the U.S. Supreme Court to require 12-person juries in all criminal cases. The bishops are arguing against particularly a Florida policy that allows smaller 6-person juries in many cases that are not capital cases. We're joined by my friend Dean John Czarnetzky. He is CEO and Dean at the Ave Maria School of Law, legal advisor to the Holy See's mission to the United Nations, and represents the Holy See in negotiations, including establishing the International Criminal Court and several international treaties. John, it's great to speak with you again. How are you?
Marcus, I'm doing very well, and it's always a privilege and honor to be speaking with you.
Likewise, time always goes by too long between our conversations, and I always enjoy them. So let's begin by sharing with our listeners this particular Florida policy pertaining to smaller juries.
Yes, thank you, and thank you for asking me to talk about this because it gave me an opportunity to refresh my recollection and learn a couple things. So it's been a pleasure preparing. Essentially, the U.S. Constitution in the Sixth Amendment guarantees a right to trial by jury. The U.S. Supreme Court made that amendment applicable to the states, as they did with many of the amendments. Originally, the amendments applied only to the federal government, but let's stipulate they apply to the states as well. Interestingly, Florida in 1968 or 69, sometime in the late 60s, decided that juries of 6 would be sufficient in criminal cases for a conviction. And that was interesting because, as the bishops lay out in their amicus brief in the case you're referring to, and there's no question they're right, the tradition, the common, so-called common law tradition, the law of England, from which we inherited American law, had always provided for juries of 12. That seems to be very well established. And the bishops go further and say that this has its roots in canon law, and the Catholic Church was central to this development. So I think everyone probably stipulates the tradition is juries of 12 in criminal cases. Florida changed that for their own reasons. And in 1970, the U.S. Supreme Court took that case up and decided that a jury of 6 in a criminal case is sufficient. Marcus, without being too pedantic, 8 years later, the Supreme Court decided that a jury of 5 was insufficient for purposes of the Sixth Amendment. So that's extremely interesting. The matter seems to have lain somewhat dormant since then. There have been some cases. And now, again, coincidentally, with regard to Florida and its 6-juror rule, the U.S. Supreme Court has accepted a case to consider, at least in part, that issue again, whether a jury of 6 is sufficient. And I'll pause there because I'm talking too much, but there's some fascinating reasons that at least I can discern, not guaranteeing that I'm right, for why they are taking this up again, and hard to predict what they're going to do.
Yeah, I'm really glad, and I always enjoy giving you the space to share, because the copious amount of research that you do gives us insight into the question. So we know that Williams versus Florida in 1970 was when Florida changed its law. So now misdemeanors and most felonies can be tried before 6 jurors instead of 12, but there are a few other states that permit smaller juries, even including for felonies. I know Florida's one, Connecticut, Arizona, Massachusetts. So it's not like there isn't a precedent and a pre-existing practice. But share with us a constitutional read and therefore the issues.
So, yes, you are correct. In fact, this happens almost every time we speak. Your research exceeded mine on precisely which states have done what Florida did in reducing the size of juries. But your question gets right to the heart of what I think is happening here, at least as reflected by the bishops. A very good amicus brief. They have, regardless of what you think of the issue, they have very sound attorneys, needless to say. And that is this: the U.S. Supreme Court has, particularly over the past couple of decades, changed. It's not an overstatement to say, not just significantly, but in fundamental ways, how they approach questions of the meaning of language in constitutional amendments. We've discussed it before when you and I talked about the list of worst Supreme Court cases. In the Second Amendment arena, cases that, for what it's worth, I tend to agree with the reasoning, that has been the area where the Supreme Court has most fundamentally changed their approach. They've rejected much of the reasoning the Supreme Court used in the 60s, 70s, and the so-called Warren Court era. Let me, as my wife says, let me land the plane. They now favor in interpreting language that is ambiguous, meaning, the Sixth Amendment says a right to jury trial is preserved in criminal cases. Okay, what are the attendant circumstances of a jury trial? How many? The court, instead of doing sort of a gut kind of, here's what we think is fair, and I'm being a little unfair at the Warren Court, but they've rejected that in favor of what did the word, in this case, jury, mean at the time of the drafting of the Sixth Amendment. So this is what they've done to uphold the right of individuals to bear arms. It's really been a revolutionary series of cases in the Second Amendment. The clever thing here for proponents of a 12-person jury is they're saying, look, regardless of what you think about Williams, it was decided using Warren Court type reasoning. That's no longer the Supreme Court reasoning. We need to look at what the word jury or jury trial guaranteed at the time of the founding. That's why the bishop's brief spends 95% of their prose in talking about the fact that jury trial in English common law and at the time of during the colonies, et cetera, always meant 12 people. So I'm talking too much, as always, but I hope that that's clear. This case, of course, is profoundly important for the right to jury trial, but it's part of potentially the extension of the court's rejection of Warren Court type reasoning in favor of this. Let's get back to the meaning of the text at the time of the drafting of the text.
I couldn't agree more that therein lies a bit of the issue, because we do have the intent of the text as it was being written. And as you mentioned, English common law and therefore the Magna Carta, the precedence in Western civilization for a 12-person jury pre-exists even the founding of the United States. In fact, I think as early as, like you said, the Magna Carta, so about the 1200s, we have this pre-existing tradition. And on the other side of the break, John, I want to invite you to comment briefly on the perceived biblical roots of the question and whether that had an influence on the matter. I'm talking with Dean John Czarnetzky. He is CEO and Dean of Ave Maria School of Law. We're talking about an issue that really is rather important for us to understand. Right now, the USCCB is urging the U.S. Supreme Court to require 12-person juries in criminal cases. The reason why is because we have a few states, including Florida, that allow for smaller 6-person juries for misdemeanors and felonies, and that can present a certain miscarriage of justice in some circumstances. We're going to continue on the other side of the break. Stay tuned. I'm Marcus Peter. Good afternoon and welcome back. I'm Marcus Peter, talking with Dean John Czarnetzky, CEO and Dean of Ave Maria School of Law. We're talking about the USCCB urging the U.S. Supreme Court to require 12-person juries in criminal cases across the states. John, I want to ask you to speak to the biblical history of this. And I know we want to be cautious here to not pretend that we are definitively appealing to a biblical principle for this, but there is a kind of biblical appeal to the precedents, and I invite your wisdom here.
Yes, and I am not a biblical scholar, nor am I a theologian, and certainly not one of your caliber, Marcus. So you jump in and please correct anything I say that's incorrect. Over the break, I was furiously trying to find in which opinion the court actually took this up, and I just didn't find it, but somewhere either in the bishop's brief or in one of the previous opinions, this issue came up, and whomever was citing it, they said, look, the 12-person requirement, it's argued, is such a well-established portion of common law because of the biblical connections. And the line was 12 apostles, 12 tribes of Israel, 12 stone. I confess I'm not quite sure what that reference is. And wherever that appeared, the author was saying, while those may, and Lord Cook, a very famous common lawyer, cited those things in an opinion 400 years ago. Wherever that appeared, and forgive me, my memory fails, said, look, all of that is interesting, but it is also liable to be dismissed as importing, it was an insulting phrase, importing mysticism into the law without proper reasoning. So that idea can cut both ways in the law. It has an appeal, and it had much greater appeal, I would guess, in older common law times.
Yeah.
But I don't recall it being strongly argued in the bishops. The bishops rely much more on the history of both canon law and the common law, rather than the biblical origins of the 12-person requirement.
Yeah, I agree. And if I may just jump in to corroborate what you're sharing, the bishops include this in their amicus filing early on. And it's only in a footnote, but the point they're really trying to make here is the reason for the 12 jury member reasoning is also because the Catholic bishops during the drafting of the Magna Carta were tremendously influential, and so even they saw a kind of biblical precedence, and that seemed to have held sway in the way they thought about the amount of men who occupied a jury. Now, but that notwithstanding, like you said, it can cut both ways, and so let's talk about the authority of English common law then, in light of how we think about our Constitution.
Yes, and this gets to what I think is sort of the fascinating legal tension in this case, and it might explain why the Supreme Court has, because they take less than 100 cases a year out of thousands of filings. So when they take a case like this, it's potentially extraordinarily important. So why did they take this case when they decided this very issue in 1970? And it gets right to your question. What is the basis for deciding 6 versus 12? Is it our general sense, modern sense of what's fair? I don't mean to parody the Warren Court, but is it sort of what 5 of us think is fair, or are we going to tie it to history and custom and tradition of our jurisprudence. That's where the common law becomes extraordinarily important. The common law history, the British history, and our colonial and subsequent history. If the court applies their reasoning from other areas, I spoke about the Second Amendment, to in this area, to say the meaning of what constitutes a jury trial is tied to its meaning of that phrase when the Sixth Amendment was drafted.
Mm-hmm.
Well, that's a very different potential result than they arrived at in 1970, where they were saying, oh, do we think 12 versus 6, does that make a difference given the reason we have jury trials? Well, we don't think it does. I hope I'm being at least clear enough where your listeners can see the difference in the reasoning might, of course, lead to a very different result than they reached in 1970.
Yeah. And that definitely provides a sound, rational basis for thinking a little more expansively about the question. And if you don't mind, I want to invite your wisdom with regard to the interpretation of English common law, especially in the thought of William Blackstone, largely because Blackstone was tremendously influential on the legal thought of our founders.
Yes, and there's been a fair amount of scholarship on this. Again, I don't mean to use weasel words.
Mm-hmm.
I'm familiar enough with it to speak as an educated lawyer. It's not my area, but there's an interesting debate about Blackstone and his to what extent he was influenced by the natural law. Blackstone was not a Catholic, if I recall, but the common law and the reasoning, and Blackstone was the authority at the time of the founding on the common law. Mm-hmm. All of the founders that were lawyers studied Blackstone, and this continued for at least 150 years. Mm-hmm. Blackstone was a subject of study. If you wanted to understand the common law, and that includes America, you studied Blackstone. So he's enormously influential. Now, he was a Protestant, and so we have the common law influenced by natural law reasoning, but through a Protestant lens, and which is the basis of our country's law. So that's a fascinating debate, Marcus, and I've pretty much now told you everything I know about it. Unfortunately, I wish I were much more deeply educated on that debate. But you're right, Blackstone, to understand legal education and the training of lawyers in this country, Blackstone is a good place to start.
One of the arguments of the bishop, over and above Blackstone, or at least any appeal to Blackstone and therefore constitutional thought, also had to do with dictionary definitions. Yes. Even up to this very day, the notion of a jury popularly seems to imply 12 people sworn to decide the facts of a case. How much bearing will that have? I know the bishop's amicus filing mentions this notion, but how much of that will have a bearing on this question?
Marcus, sometimes I think you're a trained legal historian because that is a tremendously insightful question, and let me try to be succinct. If the Supreme Court imports the reasoning they've used before, that meaning as of the Sixth Amendment when it was drafted is what counts here. The legal environment, legal resources were very, very different in 1789 than they are today. Today you can find any case ever published at your fingertips, at your desk. At the founding era, cases weren't even widely published. The primary sources for legal education, for legal thought, were things like dictionaries, and dare I say it, legal treatises written by law professors summarizing the law. Those were, at a time when case law was not widely available, those were the sources lawyers went to. So you see how, and the bishop's brief reflects this, that if the Supreme Court is interested in following strictly what the meaning of terms are in 1789, they're going to turn to the resources that lawyers used at that time, because cases just weren't available. We don't have access to deep case law on any issue, much less this one. So, of course, we can still find dictionaries of legal terms from the 1700s. It makes perfect sense. Reading the brief was just a joy for me to sort of marinate a little bit in that culture, which was very different than our legal culture today.
If you don't mind, and I know you're a man who's not given to untoward speculation, but if you don't mind my seeking your opinion here, I know that Justice Byron White, with the Supreme Court, did make a statement that the Constitution does not require 12 jurors, that it's a bit more of an historical inheritance rather than a constitutional requirement. And so I invite your wisdom and your thought on how this is going to go.
It's so difficult. I'll just very briefly tell you, I was a bankruptcy scholar, and I was talking with a constitutional law scholar at my previous law school about how a bankruptcy case was going to come out at the Supreme Court. Mm-hmm. And it turned out I was completely wrong. But if I had to predict, I hear the music.
Yeah.
I think that they will adopt the new reasoning and overturn, perhaps, that 1970 case. That's my prediction. We'll see if I'm right.
I've been talking with Dean John Czarnetzky, a tremendous wealth of wisdom, especially pertaining to legal situations, and we're talking about the U.S. bishops urging a 12-person jury. Stay tuned, I'm Marcus Peter.